Reflecting here today, we remember that on June 28th of last year, the Iowa Supreme Court reversed and remanded what was previously a permanent injunction on the 6-week abortion ban. But when they reversed and remanded this, they utilized a rational basis test, which means that the fact that this law inflicts harm on individual rights does not matter. The court held that the law is constitutional just because it's rationally related to our government's interest. And so, in doing this, our government pushed back in time women and their own individual rights, relegated to lesser citizens in this state, and placed squarely behind men and fetuses in their rights. Now, 2 of 5 clinics previously providing abortion care in Iowa remain open. And of note, this is a barrier for women not just to receive abortion care, but particularly for our low-resourced women to receive cancer screenings, contraception, treatment for infections, or even just a safe place to receive information. So this is very pro-life, of course, when we consider that it's very poignant to reduce care for women who are already struggling to make ends meet. As these clinics close, women travel further for care, spending more time and more money gathering additional childcare resources, spending resources on lodging, missing time furthering their own careers and educations. The financial stress caused by these restrictions has caused more women to seek assistance. In 2023, only 194 women sought support from abortion funds to travel out of state. But in 2024, that number swelled to 625, more than tripled. The challenges to recruitment that medical professionals like myself warned of, that OBGYNs would not want to practice in a state where their license could be at risk by providing life-saving or even just patient-affirming care, remain. Iowans' position of weakness in women's healthcare persists, and for those of us here, burnout levels are high and moral injury is heavy. Rural healthcare in particular is struggling, but metro healthcare is not much different. You only need to look to the headlines to see that even places like Iowa City and Des Moines have gone through tremendous change. This law does not eliminate abortion as an act, as a need, or as a choice. It simply punishes Iowa's women for making personal health and family choices by forcing them to confront barriers, costs, and arbitrary timelines. It diminishes their own lived experience and bodily expertise to the ongoing detriment of our families and communities. In 1846, when Iowa was admitted to the Union and its first constitution adopted, women comprised approximately 5% of the workforce. At that time, even married women could not own property, much less make their own reproductive decisions. But now, 79% of Iowa women are in the workforce, surviving and supporting their families in a state economy that is worst in the nation. A recent government accountability report confirmed that abortion restrictions negatively affect educational attainment, labor force, and career trajectories, and where people choose to live. Chief Justice Susan Christensen, in her dissent, gave us our rallying cry. We didn't come this far to say our work is done. We know that Iowa deserves better. There are better ways to protect women. Keeping women safe involves allowing them to exercise bodily autonomy, live by their own mores, and access healthcare with privacy and dignity. Let me be clear. Barriers to abortion access are barriers to equity, freedom, and liberty in Iowa. They shape the way that young girls see themselves in our state society, which is in fact a society that transfers the value of women's lives to their unborn children. No family is exempt from an impossible pregnancy decision. And as an OBGYN, I've seen these go every way: seeking adoption, seeking abortion for an unplanned pregnancy, seeking abortion for a planned but incurably ill pregnancy, and seeking emergent care for a desperately ill mother. In each of these heart-wrenching situations, I can assure you that our legislature, our governor, our attorney general, and our justices did not hold these patients' hand as they weighed the risks, benefits, and alternatives to their unique medical conditions. but I have. Whether a young woman struggling with infertility who's deciding whether to freeze embryos in Iowa or in a neighboring state, a pregnant teenager who's been shunned by her boyfriend's family with little support, a young family struggling to remain in their rented apartment who cannot support another child, or a woman coping with the devastating news of a fetal anomaly. I have held space with these patients and seen the toll of this legislation. I have counseled Iowa fathers on where their daughters can access abortion care. Conversations that demonstrate that dignified choices should be available to even those who never imagined themselves in these situations. I have wondered how to improve rural Iowans' healthcare during a moment when few physicians will choose to work here. Yesterday, a patient told me that her partner and father of her unborn child had dipped, a choice that only a man in Iowa has when a pregnancy does not serve his best interests. Women shoulder the weight of this bill and now bear pregnancies according to the will of the government. Our work remains vital. In no other life-changing, life-altering decision do we insist that a condition be specifically enumerated by a document written nearly 200 years ago. We know what is right. Patients deserve the fundamental right to make medical decisions affecting their health and bodily integrity free from government interference, language our own Chief Justice gave us in her dissent. We will continue to demand it.